Okay. Your Flagstad, if you'd like to come forward with Mr. Lejack, please. This is people. Jack, this is file number 265535. We have counsel.
Judge Mike Flagstad, 2 number 79314 on behalf of
Sear.
Sorry. Go ahead.
Judge Mike Flagstad on behalf of defendant.
Sierra Coke on behalf of the people.
Thank you. Mr. Flagstad, tell me the status of this file this morning.
Yes, Judge. Mr. Lejack has been accepted into the Wake County Sobriety Court. Our intention is to enter a plea today. Furthermore, Judge, particularly in light of our last experience, it is Lenawee County's expectation that you would be the sentencing judge, and that we would effect a transfer thereafter.
Okay. So we only set this for a sentencing here.
Yes, Your Honor.
Okay.
And approach judge.
Yeah.
Have a advice of rights, and I don't know that you need the acceptance letter, but I got one. So.
Okay. Thank you. And is there any charge or?
Yes, Judge, I apologize. The plea would be to an added count of operating on visibly impaired third offense notice. So 1-step reduction.
Okay. Ms. Koch, is that a correct statement of the plea offer?
It is.
Mr. Lejack, have you had an opportunity to speak with your attorney about this plea agreement?
Yes.
And is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Sir, are you on any probation or parole at this time?
No.
Right. And you understand that the maximum possible penalty that you could face for operating while visibly impaired as a third offense is up to 5 years or a $5,000 fine.
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
I plead guilty.
Okay. Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, Your Honor.
And can you tell me what will happen with those rights by you pleading guilty?
Jail.
That's true, but what I'm asking is, I want to make sure that you understand that you're going to get waiving all of those rights that we just talked about. So
Yes.
the right to have a trial, right to prosecutor prove that you're guilty, all of those things, you're going to be giving up and waiving those rights. You won't have them anymore based on your guilty plea. Do you
Yes.
understand?
Yes.
Do you have any questions about that?
I do not.
Also, you can't automatically appeal the plea that you're making today. You don't have a right to do that. You do that by leave. So if you wanted to get this plea that you're making today reversed somehow or vacated, you would have to ask for the next higher court up, which is the Court of Appeals, to hear your case. And they could say no, then that would be the end of that appeal.
Yes.
Has anybody threatened you with anything to get you to plead guilty? Has anybody promised you anything other than what was said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty of this crime?
Yes.
The information I have indicates this happened on January 2nd of this year, 2026. Is that correct?
Yes, Your Honor.
Okay. And on that date, had you been consuming alcohol? And after you consumed alcohol on that day, did you operate a vehicle on Highway M72 here in Crawford County. And you consumed enough alcohol that while you were driving, your ability to operate that vehicle in a normal and safe manner was impaired.
Yes.
Oh, are you satisfied with the factual basis?
I am.
Mr. Flagstaff?
I am, Your Honor.
Ms. Coke, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Mr. Flagstaff?
No, Your Honor, none.
And Ms. Coke, are the people satisfied that the court has complied with statute? The court will only take notes.
Yes.
Mr. Flagstaff?
You have, Your Honor.
Thank you. The court finds that the plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of the added count 2. The court will accept the guilty plea. We'll set this matter for a sentencing hearing. You'll be notified at the time of that hearing. Before you leave court today, you're going to meet with Mr. McDonald to set up a pre-sentence interview, and then you'll have an opportunity to go through that report with your attorney prior to the sentencing hearing. Spoke anything further today on this case?
No, thank you.
No, Judge, thank you.
Okay. I'm going to put the advice of rights form in the file. Did you want me to file the acceptance letter?
I have several copies either way, Judge.
I'll put it in the file that way. It's that. And Mr. Lejack, just make sure that you stay in touch with your attorney.
Thank you, Your Honor. Have a nice day.
Mr. Adams' case.
I am ready. I have not seen Mr. Adams in the courtroom, Your Honor.
Okay, let's call that file then. People versus Adams, file number 255414.
Sierra,
This is, oh, sorry, go ahead.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Richard Adams.
And Mr. Thompson, are you actually counsel of record or are you just standing in as arraignment?
I'm duty attorney for Mr. Adams' arraignment.
So Mr. Adams was ordered by show cause to appear today at 9 a.m. Technical violation. It is now 9:20. Mr. Adams is not present here in the courtroom. Mr. McDonald, have you had any contact with him?
I am not, Judge.
Then I would request, Mr. McDonald, that you prepare another bench warrant for a violation for his failure to appear as ordered by the court. And once Mr. Adams is arrested, brought before the court, we'll proceed further on the case.
Thank you.
Thank you, Mr. Thompson. Williams, are you able to hear me okay?
I am, Your Honor. Thank you.
Okay. And just having Mr. Price join right now. Yeah, no.
It should be LaDonna Schultz from West Branch.
All right. Mr. Williams, we don't have the, we've got a visiting prosecutor on this case. I don't see that person joined in.
I can have my office caller and then we can see what's going on.
Okay, so I'm just going to pass this case briefly, Mr. Williams and Mr. Price, and ask that you both remain on the line. And Ms. Koch, our Crawford County prosecutor, is going to contact the other prosecutor and see if they can join in.
Okay, I understand, Your Honor. Thank you. I'll just stand by.
Thank you. And Mr. Thompson, will you Doring's case?
Yes.
We'll call people People versus Anthony Doring. This is file number 255475. The record should reflect Mr. Doring present here in the courtroom today. If I could have counsel, but your appearance is not.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, on behalf of the defendant, Anthony Doring.
Okay, this is set as a final status conference in this case. We do have trial set to begin, I believe, on June 12th. Ms. Coke, I did just receive this morning your notice. There's,
Supposed to be 76827B.
yeah, I think it says 764A is not the right statute. And then Mr. Thompson, I did get your response as well.
Thank you, Your Honor. So obviously just receiving it, I would anticipate the court will on a separate motion date. But I do object to that evidence.
Okay. Let's try.
It's 612, so we,
You have a motion.
Okay. So, Mr. Thompson, typically I have defense counsel as the objecting party notice for hearing, so.
And I'm happy to do that. I wanted to get that in the court file just so it was clear that we were going to do this, not hoping to.
Okay, so we will, I'll just ask that you notice that for hearing on the court's June.
I'm happy to. Do I work with John on that or sir?
Yes, Jen.
Okay. That will be done, Your Honor.
Okay, other than that, Ms. Coke, are the people prepared to go to trial?
we are, we discussed the objection and the possible ramifications depending on the court's hearing. We are prepared for trial.
This was set as the plea cutoff, Mr. Thompson. I guess I would just say, since we're going to have another hearing in June, and because this is an issue that's been raised, that see how the decision one way or the other might affect that.
I appreciate that, Your Honor. That was part of my purpose of getting my objection in. So yes, I would appreciate the plea cutoff being extended. My clients, rejected the current plea offer and we're prepared for trial, but I would like to have flexibility, so I'm asking for that.
So the court will make that last hearing in June, the plea cutoff. And Mr. Doring, to the extent that you want to consider any further plea offers, you'd be able to do that. But otherwise, we do have the trial set for June 12th. The court's going to plan on proceeding with trial on that date. So make sure that you stay in touch with Mr. Thompson so that you can help him be prepared to go forward with trial. And we'll need you to be here at 8:30 on the morning of trial, which Mr. Thompson will explain that to you as well. Yes, sir. But we will have one more hearing in your case to address this evidentiary issue. You have any questions about it?
no, sir.
Mr. Thompson, is there anything further from your side today?
Nothing further for today's record, Your Honor. I will notice that hearing.
Thank you, Ms. Cope.
Nothing further. Thank you.
Okay, so we'll proceed in June with the motion. The court will just note for the record that we are going to proceed with trial and schedule that. Thank you, Mr. Doring.
Thank you, sir.
Versus Baker, file number 265526.
Sierra Coke on behalf of the people.
Baker, come up to the podium, please. The record should reflect Mr. Baker is present here in the courtroom today. Actually, we have this file, so 65526 and 255439. 5439 file is probation violation, so we're having sentencing as to both today. I do want to make counsel aware, if you're not already, yesterday I did request from prosecutor some of the body cam video relating to the arrest in this case. And primarily, that's not something that I ordinarily do, as counsel's aware. But in this case, given some of the things I read in the PSI regarding, I guess different versions of how things occurred through the course of the interaction that led to the charges in file 5526. Given those inconsistencies and discrepancies, I wanted an opportunity to see for myself what happened will note that all the videos that I reviewed were all of the interactions, hospital, jail, Mr. Baker during the course of the incident. One of the things that I did want to review was any interviews with Mr. and Ms. Lowe's, the victims, which I did not have a chance to see that.
I was gonna say, I don't recall recordings of those. I'm not.
And there may not be, and maybe
I
that's
think they're
why.
both present here today, though, if they did want to address the court.
Well, what I wanted to see is what they said contemporaneous, because of the differing versions, and maybe there wasn't recordings. I did request that if there were any. I'm assuming there weren't, since I didn't get any.
We downloaded everything we could get onto the drives. The court requested them. There's lots of them. So Rachel was doing them for a significant amount of time. I think she got everything she could onto a drive. We didn't find anything, but we were trying to review extensive footage yesterday. So I apologize.
No, that's fine. But I think the point of that is that I didn't see anything that hasn't been disclosed to the defense, and they don't already have a copy of.
Correct.
So I want to make record here on that. This is the date I said presented against both of these matters. And Mr. Baker, have you had an adequate opportunity to go through the pre-sentence report, both for the probation violation and the new charge with your attorney? And Mr. Trush, first as to the probation violation report, are there any corrections that need to be made to that?
No, you're right.
And then as to the PSI on new charges, any additions, deletions, or corrections?
I do have one challenge to the scoring of the guidelines. And I apologize, I would have done it in writing, but I think it was Monday afternoon when I actually caught it and recognized it.
Okay.
On the only felony count, the R or no, they're scoring for OV 18 at 15 points. I think OV 18 only scores if the offense involves the operation of a vehicle. While there is an operating while intoxicated here, it's a misdemeanor level offense. So I don't think the 15 points on OV 18 is appropriate to score there.
Is he right?
So
I'm pulling that up right now, so we didn't get a written objection, but Mr. Trush is correct that OV 18 is only scored. I just need to read it, but there is one of the OVs that is only scored for alcohol. I can't remember if it's OV 17 or 18, but whichever one says the vessel is the one that's only scored for drunk drivings.
I'm looking at OB 18. It does indicate that that is only scored if the offense or attempted offense involves the operation of the vehicle. Certainly that would apply to the misdemeanor offense, but the felony R&O, to me, that portion of the offense here was all after Mr. Baker had already driven to the hospital.
I would agree, Your Honor.
Okay, so I will sustain that challenge of OB 15, or I'm sorry, 18. Score that at 0, which reduces the OB total to 75. How does that change the scoring at all?
It does not change the guidelines range. The maximum level for a G grid, I think, is 16 plus points or something like that. So I mean, we're well beyond what that level would be.
All right, so OB level will remain the same, guidelines will remain 0 to 17. Are there any other challenges to guidelines or corrections to the report?
No, Your Honor.
Scope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do you have any changes to the probation violation?
I do not.
Do you have any other concerns to address the board today?
I believe Mr. Baker's mother may want to address the court.
Mr. Church, if you and Mr. Baker, please see at the defense table. Would come forward up to the podium, please. I'm sorry, be careful, there's a little. There's a little. What there about there? You're Miss Lowe's, is that
Yes.
correct? Okay. And can you just state your first and last name for the record? for us?
Cheryl Lowe's,
And what is it that you would like to say?
under all the circumstances that have gone on, which has been pretty crazy, I would like the court to take into consideration of sending him to a rehab and not back into jail. His mental state has always been bad. It's getting worse, and being inside where there's nobody to talk to, nobody to help him, it's getting worse. And the domestic violence charges, I still don't understand, but they have put them on him because we are the ones that went after him to get the keys. He just pushed back. There was no intent for domestic violence there. I am the only person that he does have. And at this point, the way the court has it set, when he does get out, he can't even come back to my house for a year. That's gonna put him back into a downward spiral, I believe. So I would hope the courts would take into consideration of letting him get into the rehab center that has been set up for him.
Okay. All right. So, I mean, you tell me what happened, right?
I lost control. I came home, was drunk. I snapped. I got mad. I ended up calling 911, not even understanding the circumstances that it would bring into play. I was desperately trying to get him somewhere for help, and the only place I thought to get him to was here, where he could be controlled a little bit and maybe get help, be appointed to a rehab center, because I have been unable to do that. I don't know the system. I don't know how things work. I did not know how to go about and get it. It turned into things that I never expected. I never expected the domestic violence. A quick report, what happened, I wrote down, he pushed after we reached for his keys. Yes, he drove off. Yes, he went to the hospital. The last time I seen him, he was standing in the emergency room begging for help when the officers were there. And the last words I heard him say is, am I resisting arrest? And they asked me to walk away, and they took me away. It was just an out of control situation between family.
Yeah.
And
But you
desperately-
called 911 that night?
Yeah, I don't know. Just seeing him that passed out, I don't know. I did.
But obviously you felt like you needed some help. that
Yeah.
night, right?
Not help for him. I didn't know how to get him. Did not know where to take him, what to do, how to help. He needs help. That's all I'm asking the courts to take in consideration after 6 months in jail now, that he be put in a rehab to help his mental state.
All right, thank you. And I appreciate you answering my questions. I read things on paper. That's why I wanted to see some of the videos, because it's sometimes hard for me to understand the dynamics, and I appreciate you clarifying some of those things.
Thank you, sir.
Ms. Miller.
This case has unfolded in a interesting way. I got a call from Mr. Baker's sister, who put a different perspective on this. She's not in contact with the family anymore. because she has moved away and indicated that essentially this has been the cycle of their life, is that Ben has, consumed alcohol, consumed drugs. His mother has covered for him. And then the cycle just continues, and it's been that way forever. I actually wish that Miss Lowe had sat into court on Tuesday, because another domestic violence victim came in and said almost exactly what she said verbatim. Well, he wouldn't have pushed me if I wouldn't have grabbed his keys and he was drunk and I was trying to stop him from driving. It's literally the same story that we hear, where the victim blames themselves for the fact that this person was intoxicated and they tried to stop them or stop them from hurting somebody else. And I often think, if you hadn't done anything and they drive out and they kill someone, what do you feel then? And why can't you take somebody who's drunk's keys away from them without getting assaulted? I understand how she feels. It's different than how I feel about these circumstances. But Mr. Baker, the idea that we put the charges on him and that, he needs help and we need to help him, it's not entirely wrong. But at some point, the fact that he was out, he had multiple situations happening. He was on probation by this point, not very long. If somebody wants to get help, they have the option to get help. I don't know how many times a month I hear, you need to get him help. You need to do something for someone. These aren't choices that we make for people. This is the criminal justice system. And when they have mental health issues or drug issues or alcohol issues, they can get rehab. They are not precluded from going to rehab should they want to go to rehab and stop committing crimes and stop putting themselves in the circumstance. Mr. Baker had multiple opportunities. He had a tether. He had probation. He had bond. Like, it's just one situation after another. The sister in the case asked that he be lodged for a year because she thought that would give him time to actually sober up and get some treatment that he was actually forced to do, versus a rehab program, which he has, never really been successful at when he had his own option. I don't know the answer. That's why I'm sitting here, the court's sitting there, but this is a very difficult case. And Mr. Baker, who seems very kind and nice when he's sober and has good family support and has, lots of tools that he could be successful. He just has to choose to use them. And when he doesn't, this is where we end up. So thank you.
Mr. Church.
Thank you, Your Honor. This case is unique in quite a few ways. I mean, even just looking at the charging document and how it was charged is somewhat unique. And I mean, frankly, it's because Ms. Koch isn't the one who charged it. It was charged by another prosecutor filling in. Frankly, I don't know that I've ever seen 12 counts of R&O charged in this county. And I think we all recognize when an R&O happens, it's rarely an isolated thing to one officer in one specific incident, right? It's often multiple officers who are there. And it often contains both verbal resisting or refusing commands, and at least to some extent, physical resistance, whether that's, passive, refusing to be cuffed or actually physically fighting with the officers. I think from what I observed here, this tends to skew on the side of what we see often, which is someone who is intoxicated, displaying intoxicated behaviors. He's questioning them about things that they're doing that are within the lawful commands, within them doing their duties. But to an intoxicated person, I don't think they always make that connection rationally. We all know intoxicated people don't always act rationally. I certainly can understand Ms. Lowe's, and I sympathize with her. I mean, I can imagine, as a parent, it's a very complicated situation to be in. She undoubtedly wants what's best for her son. At the same time, I think she took the actions that night that she thought were appropriate. And it's probably a mixture of both. I'm sure that at the time when this is happening, in the moment, she was concerned for herself and her spouse. And I'm sure she's also concerned for them. Those are all very normal things to express. At the end of the day, though, I think when the court looks at this case, what we have to look at is what's the right response for this situation. What we have here is someone who has, I think, a clear history of problems with alcohol. I think there may be a little bit of, I think there's some marijuana in his past too, but I mean, as I look at his history, what stands out is the alcohol. That clearly seems to be the problem. All the prior offenses that he has are related to that. His history is not terrible. He has 1 prior felony and 2 prior misdemeanors. I think we're still at the stage here where what we should be trying to do is trying to get Mr. Baker connected to the right services so he can be the person in the community that he's largely been. Right? Mr. Baker presents as someone who is 44, maybe 45 now, 45 years old, with, again, a fairly minimal history. He struggles with alcohol. That's clear from his history. I think it's clear from what his mom has said. I think he's going to tell you the same thing. Alcohol is a problem. The context of this is he was released from the jail, I think, 2 days before this happened. Right? I mean, as I look at the I think, what is it, offense, 6 days. I mean, it's very close in time, right? When I spoke to him, and we've had a lot of discussions about treatment options, but when I spoke to him, what seemed clear is I don't think he fully appreciated how much of a problem he had. And I think when he was released from the jail, he thought, I'm sober and I'm just going to stay sober. And I don't think it's an odd idea for him to have. But what happens is he's released and he goes right back out into the same situations, the same temptations, things that weren't present when he was in the jail. And he immediately falls back into the same patterns. I would suggest to the court, I think the recommendation is appropriate insofar as I think a jail sentence is the appropriate response here. What I would suggest to the court, though, is I think with almost 4 months in right now, it's an appropriate time to give him an opportunity to engage in rehab. Mr. Baker and I have spent a lot of time talking about rehabs. He's been accepted to the Lion's Den. He's also been accepted at Bear River at their center campus in Boyne. We've gone back and forth over what's the best option for him. If he goes into Lion's Den, they won't let him take his medications. And that's concerning for me because he's on antidepressant medications. He's on psych meds. And if he goes there and he's not taking those medications, mood stabilizers, I worry that that's going to have a negative impact on it. The benefits there, obviously, which we've talked about, is it's a long-term program, right? I mean, it's an 8-month program to complete it, plus he can stay on after. It also would solve some of the housing issue, right? It was already kind of raised, you know, when he leaves here, he can't go back to his mother's place where he resides. Where is he supposed to go? Bear River presents different options. It's a shorter term program, but I've talked to him about going into sober living afterwards. You know, long term, I don't think he wants to stay in the Boyne area. We've talked about when he finishes there, maybe doing sober living in the Gaylord area or the Petoskey area. But he has ability there to, again, surround himself with like-minded people who are going to help him, you know, build a community with people who are looking for the same goals, right? They've got sobriety at the forefront of what they're doing. I think that is a better option for us here. I think it's the right response. It holds him accountable for the actions he's done while giving him an option to show the court and to address it. And again,
Your Honor, does the court want to take a short break? We do have 2 special prosecutors who have 2 full dockets that are both on hold. Their judges are both waiting for our dockets to end. So I don't know if the court wants to take a break. I'm just saying they're both sitting there waiting for us.
I tried to call Ms. Schultz's case. She wasn't on, so I couldn't.
I understand they,
Got involved in this hearing, so I'd like to finish out this hearing. I appreciate
thank you.
counsel, but we're almost at the end here, so.
I think, Your Honor, to go back to what Ms. Koch said about Ben's sister, I mean, I think that's a point well taken, right? Being in recovery of your own devices is certainly an option for him. I mean, if the court imposed a sentence and he did it afterwards, it's certainly an option. But I think we all recognize if he has jail over his head, it's going to be another thing to motivate him going on days when maybe he wouldn't otherwise, right? When he has the dark day and he's thinking about quitting, it's another motivator for him. I think that's the right response. If the court is inclined to do that, I have prepared a supplemental order regarding rehab.
All right, thank you, Mr. Baker. Is there anything you wanted to say?
I thought it was really strong enough to, do outpatient, but it clearly wasn't. Structured environment or something else.
All right, I read through both reports. I was already familiar, Mr. Baker, with your circumstances based on the previous case that we're here for the probation violation on. I read through the report very carefully. Charges, as I indicated, I watched a lot of the video, so I saw pretty much the interactions that occurred between law enforcement on the night of the new incident. Ms. Lowe's, and I listened very carefully to what you said, obviously, and I certainly take that into consideration when I'm trying to decide what is an appropriate way to address this. And it is a difficult question for the court because, Mr. Baker, a lot of your behavior is dangerous. It's assaultive, not just towards, if we take out the whole thing with your parents. Your behavior outside of that is assaultive and dangerous. Getting in your vehicle and driving in the condition that you were in put everybody else at risk. You already had a previous operating while intoxicated offense back in 2015 or 2016. 2015. So this isn't really a new problem. It's just something that you, for whatever reason, have chosen not to address. And in the probation file, you were given an opportunity with probation with 7769-4A to have that come off of your record, and almost immediately after being released, you fell right back into your previous behavior. So starting in 2016, from your previous drunk driving arrest, there just isn't a lot of evidence that you've done anything on your own to try and deal with this problem. And I don't know if the court ordering it is going to make you do it or not. If you're not willing to do it on your own, usually the court ordering people to do it isn't successful either. I mean, you have to want to do it yourself.
I went to Fairwood or Harvard Hall.
Yeah.
15.
So, when you're not willing to help yourself, it's hard to come to the court and say, well, I want you to help. Particularly again, when your behavior is not just dangerous to yourself, but dangerous to other people in the community. And I have an obligation on behalf of the community, not just you, not just your family. All that being said, I do think that rehabilitation should be part of the court sentence in this case, and it's something that the court needs to look at and should look at, because I don't think jail time alone is clearly not going to solve the problem, and it's not going to make the community safer in the long run. But I do think a lengthy jail sentence is warranted, in particular by your behavior that night, both towards your parents and law enforcement, and by the danger that you pose to the entire community by driving the law enforcement resources that were diverted from other needs in the community that night to handle what you were doing. Or at least 5 or 6 officers that were taken away from their normal duties to address the situation that puts the rest of the community in danger as well. So for those reasons, in terms of the new file, the court finds that a 12-month sentence is warranted. It's within the guidelines. And I think your behavior and circumstances make that a reasonable penalty. However, if you are able to get into and provide confirmation of a inpatient rehabilitation, residential rehabilitation program, the court would allow you to be released 30 days early to attend that rehabilitation facility. You do have 112 days credit. The court is going to order restitution in the amount of $1,945 payable to the Crawford County Clerk, be dispersed to the Crawford County Sheriff's Department. Crime victims assessment of $130, court costs of $325, attorney fees of $350, and testing fee of $60 and a $68 state cost as to the resisting or obstructing offense. Count 2, the court will sentence you to 112 days in the Crawford County Jail with credit for 112 days served and a $50 state cost. Operating while intoxicated, 93 days in the Crawford County Jail with credit for 93 days served. $100 OUIL reimbursement and a $50 state cost. With regard to the probation violation, I do think given your conduct, it's appropriate to discharge you unsuccessfully from the probation. Court will order that you serve 93 days in jail with credit for 93 days served. All remaining costs will be reserved. You do have the ability to appeal both of these sentences. And Mr. Trush, if you could have Mr. Baker now receive it. Great. Ms. Schultz, you could unmute, and Mr. Williams, please. And we'll go on the record in People versus Price. This is file number 255467. Record should reflect that Mr. Williams and Mr. Price are both present by Zoom video. In addition, the presiding prosecutor, Ms. Schultz, is also present by Zoom video. This is set for a final status conference in this case today. And Mr. Williams, we do have trials set to begin on June 10th. This is the plea cutoff. Have you had an opportunity to speak with your client about the plea cutoff portion of this?
Yeah, I have, Your Honor. There are some other serious issues that have developed since our last hearing. Is it possible to go do a Zoom in chambers with Ms. Schultz off the record, and then I can make a record after? But there's some very, very unique issues in this case. So if we could have a chambers conversation, if not, I can do it all on the record. I'm just asking.
Yeah, I don't have the ability to do breakout rooms in chambers, so it would have to be on the record.
So a couple things. I believe there's some evidentiary issues that I became aware of last week. I was prepping for trial, and I'll try to keep these in order because there's many. Miss Kobe.
Before you go into all of that, what are you going to be asking me to do today?
A couple things, Your Honor. Mr. Price is indigent. One of his family members agreed to retain me. He has since then backed out of the agreement. I'm not going to leave Mr. Price hanging at this point, but I did contact Mr. Thompson's office this morning to discuss if I need at least money for a private investigator. I'm asking if they could assign the case to me. That's not the court's problem. That is not the issue is funding for private investigator. I'm going to ask the court to set the trial date out because there are several witnesses in this case that, for instance, the county prosecutor recused herself. She's a key witness in this case. I believe there are communications that have not been provided to me that would have occurred, that I would be asking for, that occurred between the prosecutor, law enforcement, and perhaps another attorney that also works in this county. There's a reason why she recused herself. I think she might have been on, and I don't know this, it's just all I can hear is voice. I asked someone else to do voice recognition. She may have been on the 911 call initially in this case. So I'm going to be filing a motion to compel on certain communications, and I believe that'll turn into an evidentiary hearing. I'm also going to request time to see if the indigent folks would, at least, if they will assign us the case, great, but at least assign us funds for a private investigator. The listed victim in this case provided the government a list of witnesses that she contacted the day of. None of those people have ever been interviewed. Because it's a life offense case, and because I've done too many of these, I do not want to be sitting in a Ginther hearing being asked these questions. So I did not know that Mr. Price's relative was going to back out of the agreement. He informed me of that literally in the last week and a half or so. And I realized that going back through the 911 call, there's probably other communications that occurred that day that are very important to his defense that I need to at least flush out. So I just don't foresee that information being provided in a way that's going to be available to prepare for such a serious situation.
Mr. Williams, I mean, you've had this case, looks like you filed your appearance last June, so almost a year ago. The case was bound over in September. I mean, is there a reason why some of this investigating hasn't been done before now? I mean, I get the part about the relatives not wanting to continue to fund the defense, but aside from that, the evidentiary issues.
Your Honor, the evidentiary issues are, again, I re-listened, and I know Ms. Koch's sitting there, so I don't know whether it's her voice or not. I don't want to make a record of it right now. But I believe that if the communications can be produced forthright, great. As far as the investigating goes, frankly, it's the government's burden. I just feel like because I am the lead counsel here, I did intend to interview these people. I did talk to Ms. Schultz about that. She told me she may have them interviewed. It hasn't occurred. So if I could move forward as scheduled, Your Honor, and I don't want to delay it. If this information could be provided forthright, I'm going to want any text communication between Ms. Koch, Adam Vernon, and law enforcement that day, and any days thereafter that discuss this case. These are people this person contacted. This case starts out in the morning with a text conversation with her saying, I definitely wasn't raped. And then you have the chief law enforcement officer over at her house, I believe present during the 911 call, even communicating on it. And I believe, and I don't know, a communication occurred between the law enforcement officer who investigated and Ms. Koch, who recused herself. And he concluded this I don't know if the court read the preliminary exam transcript, but he concluded within 37 minutes of never even interviewing my client that a CSE 1 occurred. And when you listen to the 911 call, it's very clear that the government is telling this person she was sexually assaulted, and her story changes. So whatever communications occurred between Ms. Koch and anyone that morning regarding this case are very important to this. So if all of those things can be provided forthright, I will work with Mr. Thompson. He is very reasonable about these matters. I doubt that'll be an issue. I can move forward. I don't know if Ms. Koch will object to her subpoena. I don't know if Mr. Vernon will object to his subpoena. I'm just bringing the court aware of these issues that could possibly that are possible issues. It's just such a serious case. I want to make a record, Your Honor.
Okay, all right, thank you, Ms. Schultz.
Your Honor, the people are ready to proceed. I did have a phone call with Mr. Williams a few days ago when he mentioned that he wanted Miss Koch interviewed. Quite frankly, Your Honor, she's not a arrest eyewitness. She was not there when this crime occurred. She was called after the incident as a friend over to the house. I think anything she knows would be hearsay and probably not admissible. My understanding was Mr. Williams was going to file a motion on that, but the motion was never filed. I'm not sure if he's planning on doing one in limine, but as far as the people are concerned, we're more than happy to accommodate him with additional discovery. The stuff he's asking for is stuff we do not have. We would have to produce, but it's evidentiary value as far as the people are concerned. Most of it is not relevant or would be barred by the rules of evidence.
If I may, Your Honor, I don't have to file any motions. And frankly, if the people want to, that's what I'm getting at, file motion limiting to preclude this, then they should do that, because Ms. Koch is the chief law enforcement officer of the county, and she clearly counseled this person and interacted with law enforcement and even appeared at the arraignment and made derogatory comments about the case. So this is a serious case. It goes directly to the heart of the defense of this case. And if the people want to make a motion, then they should. I'm intending on calling Ms. Koch as a witness. I'm intending on, if I don't receive the information, I'm intending to subpoena the phone and text records of everyone involved, and I'll flush it out at trial. But again, I don't have to file any motions. I don't have to prove anything, and she is a listed witness that will be subpoenaed.
Excuse me, Mr. Williams, I'm not saying you have to file. I'm just saying that not the last time, but the time before that, when we talked, you said you were.
But I rethought that, and I thought, why do I need to file anything when she's a witness? I just put her on my list.
All right, okay. Well, I mean, that's all academic between the two of you. From the court standpoint, this is a final status conference. We did have a scheduling conference back in December. The court issued a scheduling order, which indicated that all motions were to be filed and heard no later than the final jury status conference. Outside of the issue of the family not wanting to continue to fund the defense, everything I'm hearing indicates that none of these are new issues. So any motion should have been filed by now. Again, Mr. Williams, you were retained on this case almost a year ago. It was bound over in September. We had the scheduling conference in December. The court set this date and the trial dates, and those notices were mailed out by the court on December 16th. So everybody's had all kinds of time to take care of all of these issues well prior to a month before trial. And to the extent that the defense didn't investigate or didn't re-listen to things or are just now determining that they need to do more, all of that should have been done earlier, in my view. And so to the extent that that can or can't be done between now and the trial date, I consider all of those things to have been waived by the defense by just the mere passage of time and the amount of notice that everybody's had of these dates and the amount of time that everybody's had to get fully prepared. It'd be fully advised in when they were going to need to have this stuff ready. So I'm not hearing anything that's any reason to adjourn at this point. And so the court is not going to adjourn the trial, and we'll proceed on June 10th as scheduled. Today is also the plea cutoff, so it doesn't sound like we have a plea agreement. The court will not accept any pleas after today. So both parties need to be prepared to go forward with trial as scheduled on June 10th. So Mr. Price, I'll just ask that you stay in touch with your attorney and that you make sure you do everything you can to help him be prepared. I'll expect all counsel to be here and ready to begin jury selection by 8:30 on the morning of trial. Ms. Schultz, is there anything else we need to address on behalf of the people?
I have nothing.
Mr. Williams?
Yes, Your Honor, just to be clear. You're right. I've had this case for a long time. I'm more prepared probably than anyone in the room right now. I could go to trial today. I'm raising these issues because they're important issues that should be raised. And if this case gets reviewed by an appellate court, the big issue is whether or not I get the discovery that I'm requesting. And it is difficult, but I'm staying the course, which most attorneys wouldn't. And I'm sticking on with Mr. Price, even though I'm not. The agreement wasn't honored. So I could go to trial today. I'm not unprepared. I don't want the court to misunderstood what I said. So I just wanted to raise these issues. I appreciate the court's time. Thank you.
Okay, well, again, any discovery that you haven't gotten, there should have been motions filed to compel well before now.
I'll subpoena it, Your Honor. That's fine.
Yeah, I mean, in my view, all of that stuff should have been done. And you've had plenty of time to figure out what you would need to get and what you wouldn't need to get. So I'm glad to hear that you're prepared and we'll go forward then. All parties are free to disconnect. Thank you.
Thank you.
I don't get to speak.
It is. All right, Ms. McGregor, I'm sorry for the delay. What's that? Yeah, Mr. Roby, can you take care of Mr. Roby's case?
We certainly can.
Okay. I'll keep Joseph Roby, number 265520.
Thank you, Your Honor. Richard Trush, on behalf of Mr. Roby.
Sierra Coke on behalf of the people.
Thank you, Your Honor. This is the time set for a status conference. It was set for 9:30. We're nearly an hour past it, and Mr. Roby is not here. Last communicated with him about a week ago where we discussed this. He did not give me a clear indication of whether he intended to have a trial set or accept the offer. I do recall, I think his bond was revoked based on an allegation of contact with the victim. That's the procedural background, but he is not here today. Let's vote.
I don't have any additional information.
Okay. Based on Mr. Roby's failure to appear, the court will request that he will prepare a bench warrant. Once he's arrested and brought before the court, we'll proceed further with this matter. Ms. McGregor, are you ready? You have a break? You're muted.
I'm sorry, Your Honor. I'm studying in court trying to run a whole docket. I thought it was my case and then I thought it wasn't. Can you hear me?
I can, yeah, and I apologize for the delay. We're a little bit behind here as well, so
That's okay. I just had to make sure that plea kept going and then the judge let me step out. So I'm sorry, I didn't hear, but there was a plea offer made. I'm not sure what we're doing.
Okay, so we're on the record in People versus Michelle's file number 265549. Ms. McGregor, we did not do anything before you were able to get on the call, so we have not done anything in the case yet.
Okay.
Mr. Trush, can you tell me the status of this file?
Your Honor, we do have an agreement in place. Did the court only set the new file, or did they set the probation violation as well?
Just this file.
Just the new file.
Well, we intend to take advantage of a plea offer that contemplates a plea to count 1 as well as count 3, and effectively would ask court to take the basis for the probation violation as well.
Do you have that case number?
255502.
Thank you.
There we go.
I can add it on mine, we'll just.
Sure.
Great, okay.
All right, Ms. McGregor, is that a correct statement of the plea offer in this case?
Yes, Your Honor.
So it's counts 1 and 3 with no habitual. Is that right?
And dismissal of
Correct.
count 2.
All right. Mr. Michels, have you had an adequate opportunity to speak to Mr. Trush about this agreement? Yes, sir. And is that how you wanted to proceed today? Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Mr. Michels, you understand that by pleading guilty here, that that's also going to result in a violation of your probation. And is it your choice to plead guilty both to violating your probation and to the charges as indicated in the new file? Yes. So I want to make sure you understand, number one, that the 2 charges you're pleading guilty to here, the first one, possession of methamphetamine, carries with it a maximum possible penalty of up to 10 years and a $15,000 fine. You understand that? Yes. And that the charge in count 3 of maintaining a drug house, that's a high court misdemeanor, 2 years and or $25,000 fine. You understand that? Yes. Mr. McDonald, can you tell me the charge for probation?
Sorry, Judge, I didn't have this on my docket.
It would have been a 10-year felony possession of methamphetamine
Okay.
under 7411.
It'd be count 4, Judge.
Okay. So, Mr. Michels, that also applies to your underlying file that you're on probation. All of that in mind, what is your plea to 1 and 3 for the new file? And you're also pleading guilty to violating your probation on that basis, is that correct? That's correct. So, right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You also have the right to have a hearing as to whether or not you violated your probation. You understand that by pleading guilty, you're going to be giving up all of those rights. And you also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. You understand that? Has anyone threatened you with anything to get you to plead guilty today? Has anyone promised you anything other than what we've said here in court? Is it your own free choice to enter this plea? Yes. Are you pleading guilty because you are actually guilty? The information I have indicates that this took place back on March 31st of 2026. Is that the correct date? On that day, were you here in Crawford County? Yes. And did you have possession of some methamphetamine? Yes. Did you know that that's what that substance was? Yes. Did you have any legal right to have any amount of it at that time? No. All right. And were you living here in Crawford County? And were you using your residence to either keep your methamphetamine or to sell it to, or give it to other people? Ms. Pope, are the people satisfied with the factual basis? I'm sorry, Ms. McGregor, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Trush?
I don't know if the court asked, just one additional question. On that date, you were on probation,
Yes. Oh, yeah, thank you.
and one of the conditions of your probation was not to possess any controlled substances.
Yes.
I think now there's a factual basis for everything.
Thank you. Ms. McGregor, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Trush,
I'm aware of none.
Ms. McGregor, are the people satisfied that the court has complied with statute, court rule, and the taking of these pleas today?
Yes, Your Honor.
Mr. Trush.
Defense is satisfied.
As to the new charges, Mr. Michelle's, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of counts 1 and 3 based on your testimony as to those 2 counts and the fact that you were on probation at the time that that occurred. The court finds there's also a factual basis to support a finding that you did violate your probation. The court will accept the guilty plea as to all matters. We'll set this matter for sentencing hearing. The probation department will prepare a new report and you'll have a chance to go through all of that with your attorney prior to the sentencing hearing. Ms. McGregor, is there anything further on behalf of the people that we need to address today?
No, Your Honor. Thank you for letting me appear Zoom.
Yeah, thanks for your patience, Mr. Trush. Anything further?
No, Your Honor, thank you.
All right, thank you, Mr. Michelle. It's all with you. And Ms. McGregor, you're free to disconnect at this time. Okay. Do you know how we ended up with Mr. Love? Is he being brought here?
So he is not being brought here. As I indicated, I don't expect that the prosecutor would have prepared a writ because I don't think they could have known anything. I contacted the jail yesterday, made them aware of it, and I had staff reach out this morning to get him on. I don't see him on there yet, but we do have Mr. McDonald, and then I can call the.
Actually, the jail in Otsego just popped in, so.
Perfect.
Okay, good morning. I can't see which officer that is, but we are just looking for Mr. Love.
We have him right now.
Okay, great, thank you. All right, Mr. Love, are you able to hear me okay?
Yes.
We're on the record in People versus Larry Love, file number 255486. The record should reflect that Mr. Love is appearing today by video from Otsego County Jail. We addressed his appearance by video yesterday on the record in Otsego County. Mr. Love, I know we just had a hearing in Otsego County yesterday, but there was a separate report prepared for the hearing today. And did you have a chance to go through that report with Mr. Trush?
Yes.
Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
And I do want to note for the record that the court, along with the PSI, did receive a report from Ms. Henderson at Community Corrections pretrial supervision that indicated that Mr. Love was in full compliance with his terms of bond during the pendency of the case, and that he only had one positive test that was for alcohol back on February 18th of 2026. But that he did acknowledge using alcohol and just received a warning for that. Otherwise, he was in full compliance. Did you want that attached to the PSI?
Yeah, sure.
Okay. So, do the people have any additions, deletions, or corrections?
No, Your Honor.
And do the people have any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for Al?
Okay, sorry, we were talking about yesterday's sentence because I wasn't familiar with it. The guidelines are appropriate. Mr. Love, I have actually known Mr. Love I've been the prosecutor for a decade, so at least that long. He is a nice person who has a lot of potential that can't get past addiction. His last meth case, he did 18 months. You know, you think to yourself, hey, if I do this again, this is where I'm going to end up back in prison. Doesn't seem to compute with him. He's 47 years old. He has a juvenile record, 26 misdemeanors and 6 felonies. It's sad to say that it seems like he just wants to end up in prison. I don't know what else there is to say I think the top end of the guidelines is probably appropriate, but we have the other case in Otsego that's controlling anyway. Thank you.
Mr. Trush.
I'm not gonna belabor the point much here. I made, I think, a pretty impassioned plea to the court yesterday in regards to Mr. Love. His record obviously works against him and speaks against him. I think there was reasons to think that he's making positive steps. Unfortunately, it might be a little, day late and a buck short, so to speak. I think if the court is within the guidelines here, and I certainly see nothing aggravating to exceed them, it would be subsumed by the sentence in Otsego County. I would suggest to the court, I think the recommendation of a county jail sanction there is appropriate. But again, frankly, unless the court exceeded the guidelines, it's going to be subsumed.
Thank you, Mr. Love. Was there anything that you wanted to say today?
No.
Mr. Love, of course, we had our hearing yesterday. I don't have anything really to add to the sentencing hearing today. I think I articulated to you my view on the case and what the appropriate sentence was. The circumstances here really change that analysis. And I think Ms. Koch also adequately pointed out some of the things that I addressed yesterday in terms of the past history. And Mr. Trush did to it here today, where we're kind of in a day late and a dollar short given your past record. So the court finds that a sentence within the guidelines is appropriate. The court is going to sentence you to 23 months to 10 years in the Michigan Department of Corrections. That is to be served with your Otsego County sentences. The court is going to order a crime victims assessment of $130, court cost of $325. And that could impose an additional attorney fee. The court is going to also not impose a DNA testing fee because that was imposed yesterday, and a $68 state cost. You do have credit for 1 day served. You do have the ability to seek an appeal of the sentence. If you haven't received it yet, you will be provided with an acknowledgement of your appellate rights. The time for filing for an appeal will not run until you actually receive and acknowledge receipt of those. Ms. Koch, is there anything further we need to address in this case?
No, Your Honor.
Mr. Church.
No, Your Honor, I'll drop the appellate rights off at the jail center.
Thank you. For the record, it does appear that Mr. Love is not in front of the camera and is not wishing to further participate. In any case, that's the conclusion of this hearing, and the court will disconnect at this time.
They added them at 10:15. No, I don't.
Your Honor,
Yes, sir.
just for docket management, Mr. Quack did arrive. He is in the lobby. He's reviewing his PSI right now. So I just have a few more moments if that works with the court's docket.
Yes.
Thank you.
Yes. Mr. Nickel, if you come forward.
Is that
please.
person?
That's Mr. McDonald.
Sorry. What's happening here? Okay.
Mr. McDonald. and Mr. Barron.
I don't know who the second person is in there.
Yes.
I know.
Mr. McDonald.
I don't know if I have that on my document. Failed to agree. Oh, you got it? Okay.
Late yesterday.
have to take a quick break to get this added, so take about 5 minutes and we'll come right back on record. We're ready on Mr. McDonald's case. So Mr. McDonald, please come forward, please. This is file number 204650. The rest will reflect Mr. McDonald's presence in the courtroom today. Mr. McDonald, you're before the court today for looks like an alleged probation violation from back in February. Do you understand why you're before the court? Mr. Trush, have you had an opportunity to speak with Mr. McDonald?
I did, Your Honor, by way of arraignment, on the probation violation, we waived a formal reading, stand mute to those charges. He has been screened and approved for counsel previously. While these are new allegations, and I think they're essentially under the umbrella of what's already there, so I don't think we need to make another appointment on it. And then I think we do have a resolution.
Okay.
In regards to the new violation, the one dated February 27th, 2026, he would be making a no contest admission to count one. He indicates to me that the charges in Roscommon County, he just had a preliminary exam. The preliminary exam bound the matter up to the circuit court. But he indicates he has not had his first circuit court hearing yet, and he hasn't made an admission yet. That's different than what Mr. McFalda indicated to me, but obviously I don't want him to make a guilty admission here if in fact there is something else out there I don't know about.
I guess I'm not following. How do we, is he guilty to one of those today?
He would plead no contest to
No
count one.
contest. Okay, I missed that part. I was reading, sorry.
Okay, and again, the basis, he indicates he hasn't pled there yet. Mr. McFalda said he thinks he has. For my purposes, though, if I'm not certain of it, I don't want him to jeopardize that. In addition to that, there's, I think, there's another violation from back in November of 2025. I'm sorry.
It's actually 3 violations, Judge. It's a confusing case.
I can see.
All right.
There's a lot
going on.
Okay. This is the November one?
There's the original show cause was set back in October for failing to report, failing to make some payments. Then he failed to appear for a show cause on November 3rd, at which time a warrant was issued. And then subsequent to that, he picked up more charges in Roscommon. But the court computer in Roscommon shows that he did plead guilty on the 5th of May to possession of cocaine. I don't know, they're saying he didn't plead guilty, but the matter shows in the court computers that he pled guilty to possession of cocaine, and he's set for sentencing on July 7th.
Okay. Again, I don't know that. I know what he's indicated, Mr. McCall has indicated, and Mr. McDonald has.
Mr. McDonald, that was 2 days ago. You don't remember if you pled guilty to a charge?
I had to put in like a promise plea.
You enter a guilty plea. Kind of.
I'm supposed to on my next hearing. I'm gonna plead guilty.
I don't know how we would take no contest plea.
They've been really stretching it out over there. I didn't even have court for 4 months. So.
Well, I'm not going to take any pleas in this case today. I'll just indicate that it's standing mute. I agree. I don't know how we take a no contest plea to a probation. And that I don't. Promising to plea, that sounds like an odd procedural mechanism there. So,
Understood, Your Honor. I believe that we have a date currently set for the 18th.
Okay.
In front of Judge Hunter. Okay. And again, I think this got moved up because effectively he moved from Roscommon to here, and it essentially then triggered as an in custody.
Okay. So yeah, I'm gonna enter a not guilty plea on behalf of Mr. McDonald today. I'm not going to try to take a no contest plea if you're not comfortable with your client making admissions. I totally understand that. So we'll set this for hearing along with the other violations scheduled before Judge Hunter. addressed. At the same time, I'm assuming by that point, the plea issue with Roscommon will be resolved. Do we need to set a bond pending that hearing, or?
I think we do need to set a bond.
Mr. McDonald?
Judge, I'd ask for a high cash bond. This Mr. McDonald has had multiple failure to appears. That's kind of how this all started. Wasn't reporting, failed to appear on October 2nd. It failed to appear on October 16th of 2025. Show cause was set, failed to appear for his arraignment on that. Let me get this information. On November 6th, he actually came and seen Agent Haven before he retired. And as they were verifying the warrants and lien, he was told to stay in the lobby. He actually left the courthouse and wasn't able to be arrested on that date. And then he was arrested January. He was arrested. So really confusing. He was arrested shortly after that in possession of 18 grams of cocaine in Roscommon County, where he has been lodged, for part of this time. According to the court records there, he pled guilty 2 days ago on the 5th, at which time he was given a PR bond. I think there was a promise or a plea for like a 90-day cap. I think that's probably why they gave him the PR bond there. But he hasn't been reporting. It's got a long list of non-compliance here. I just asked for a high cash bond, Judge. I just think he should be held until the hearing, to be honest with you.
Your Honor, I wouldn't spoke to Mr. McDonald about the bond issue today. He reports, and he's been lodged since I think roughly February of this year. He does not have funds available to post. He reported that he probably could come up with $400 or $500, and that's about it. So I just asked court to take his financial situation into account in terms of setting a bond.
All right, I mean, just looking at the file, Mr. McDonald, it looks like we got a lot of problems getting you from the board to get these things resolved. And so I agree with Mr. McDonald that a substantial cash bond is necessary to ensure your appearance in June. So the board,
If I ever received a notice, I would have been here.
not sure.
Apparently, they don't have my address, even though I've been on probation for 4 years, same address.
So it's their fault, not yours, for all those times you're not showing up.
I showed
Been
up.
leaving
I
the
showed up at my
courthouse.
probation officers 3 times, and she made me sit in the hallway for 4 hours before I finally just left.
Okay. So that's her fault too.
Well, I do have a job that I was about to be fired from.
Well, this way we're gonna make sure that we don't have address problems, and we'll make sure that we get the hearing. That's just the way we do that.
Okay.
So the court's gonna set bond in the amount of $25,000 cash or surety, with all standard conditions of bond and all terms and conditions of probation. And then we'll proceed on June 18th. That's all, Mr. McDonald. Thank you.
Just to be clear, May 18th is the date that Judge Hunter currently set.
Yes.
May. People versus Farron, are you Mr. Farron?
Yeah.
Okay, Mr. Farron, come forward, please. Mr. Farron, we're gonna ask Mr. Shermer, your attorney was on and he has disconnected, so we're gonna have to get him connected again. So, have you take another seat back over there? I'm sorry about that.
Yep.
And Mr. Thompson, are you ready on Mr. Quack's case?
Yes, thank you, Your Honor.
Judge Roby said he's just jumping back on.
You're gonna stand right here, Mark.
Hold on, I guess.
Court, continue, Mr. Farron.
So.
All right, Mark, I guess we're next.
morning, Mr. Gurmurthy. Are you able to hear me okay?
Good morning, Judge. I can. Thank you.
Okay, all right. Mr. Farren, I'm sorry. Okay, we're on the record in People versus Farren. This is file number 265529. The record should reflect that Mr. Farren is present here in court today. And if I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Honorable Gurmurthy, on behalf of Mr. Farren.
All right, the court set this for a status conference today, added this to the docket. Primarily, Mr. Farren, you've been sending a lot of communications to the court, and when you're represented by an attorney, I can't look at those things without having the prosecutor receive copies. And when you have counsel, your attorney is the one that kind of speaks for you and files things on your behalf. And so, number one, I want to make sure you understand that if you have something that needs to be filed, you have motions that you need to file, and those are things that you need to address with your lawyer and have your lawyer file those things for the court. Do you have questions about that?
Yes, I understand under the Constitution, I have a right to counsel. I also believe I have the right to file motions. I understand that counsel has a right to move forward with trial in his opinions and theories, but also I'm thinking of my appeal, and issues need to be raised with the trial court in order to be addressed on appeal. If they're not raised, then they're not issues. So my concern, I'm facing multiple life sentences. If I'm found guilty, I'll get more time than El Chapo. So I'm trying to protect my rights at the same time. And I served all the parties when I filed the motions. So I'm just trying to safeguard my rights. Under the Constitution, I have a right to petition the government for redress of grievances under the First Amendment. So I believe that having counsel shouldn't restrict me from filing motions or lodging issues on record as well.
Mm-hmm.
So,
well, like I said, your lawyer speaks for you. So that's how your rights are exercised, is through your attorney. You have the right to represent yourself, and so you can certainly do that as well. But you can't do both, because then you're speaking with two different voices, and you don't have a right to speak with two different voices. So I guess the decision you have to make is whether you want to have an attorney, which you do have the right to have an attorney. And if you can't afford one, one can be appointed for you. And I believe, Mr. Gurmurthy, are you appointed in this case?
I was, Judge, and just for the record, there is no breakdown between Mr. Farren and myself. So we're Mr. Farren and I are plugging along just fine. But I understand Mr. Farren's position. I've had the same conversation with him, but he intends to and wants to file his own motions. I can't stop him from doing that. But I think the court's addressing that as well. But I just wanted to make the record clear. Mr. Farren's not asking for new counsel. He and I are plugging along. We're preparing for trial. Ms. Koch and I are negotiating. I have those discussions with Mr. Farrell, and we come back and forth. And we're doing what we do, litigating a case, going to trial. So all of those things are happening. But Mr. Farren wants to file motions on his own, and I think in his mindset that he has the right to do so, and he's exercising that right to do that. So I can't control that, Judge.
All right, well, and I understand what you're saying, but again, my view is that you have the right to speak and to seek redress of grievances, certainly, but you don't have unlimited means of doing that. And so the court's going to continue doing what it's been doing, which is returning anything that you file on your own to you and sending copies to Mr. Gurmurthy so that he is aware. But that's what I wanted to address today. Ms. Koch, is there anything that we needed to address from your side?
I would only say the same issues apply to our office. We have gotten numerous letters we have sent them back because he has an attorney and I don't want to have communications with Mr. Farren outside of his attorney. So we're in a tough situation. Mr. Grimuthi and I have talked about this case ad nauseum. He is strongly litigating for his client. I made what I thought was a very good offer for assault with intent to penetrate the lower end of the guidelines. We have went over that with the victim's mother in this case. She was on board with that plea offer. Mr. Grimuthi indicated that they are not accepting that plea offer and would like to go forward on the charges to a jury trial.
All right, so then we'll proceed forward towards trial, which I believe is scheduled for July, early July, is that right?
Yes.
Okay.
I think it's mid-July.
Or mid-July. So, yep, we plan on going forward with trial. We do have one more hearing set, final status conference in early July. So that'll be the next. Or do you have any other questions?
Yeah, one more question, Your Honor. How do I lodge issues on record that I'm opposed to as far as evidence or witnesses or other issues if I can't file the motions? How do I do that?
Again, your attorney is everything, the way that you express anything with regard to the case is done through your counsel.
I understand, Your Honor. My issue is I don't want to file ineffective assistance of counsel on Mr. Grimuthi because he's a good attorney. However, you know, there is points where an attorney wants to go one way and the client wants to go also another way. And I'm just trying to safeguard how I put these issues on the record to preserve them for appeal, you know, because like I said, if I'm found guilty at trial, I'm never going to get out. So I want to make sure and preserve my appeal rights.
Yeah. So, I mean, I can't give you advice on how to do that. I guess the best thing you can do is talk to Mr. Grimuthi, express those concerns, express that there are things that you want to make sure are preserved for appeal, and he can advise you on the best way to do that.
Well, and you know, I think Mr. Farron's question is trial strategy. I've informed him that trial strategy usually.
Sorry,
Is
Robbie.
If there's an echo, just let me know. I don't hear it.
No, we're good. Go ahead.
All right. I think Mr. Farron's question is the trial strategy usually rests with the attorney, and Mr. Farron would like input in that trial strategy and objecting to any notices that Ms. Koch filed. So far, none have been filed. And I've informed this to Mr. Farron. I'll say it again. When we get closer to that and responding to those motions, we'll deal with it when we have it. We don't have it yet, so it's a little premature to address those at this point, Mr. Farron. But we will address those issues. You know, we've got our expert. I don't want to give away a lot of our privileged communications, but the question you're asking is a little premature of the court right now. The judge can't give you advice. He can make rulings and rule one way or the other. And certainly those rulings will be part of the record. And if there's an appeal issue, an appellate court will review those issues. But right now, those are just a little premature. But we'll talk about strategy and stuff as we get closer. So nothing's changed since what I've told you the last time. It doesn't change today.
All right. Thank you. That's all for today.
All right. Thank you, Judge.
Thank you, Mr. Grimuthi. You're free to disconnect at this time.
All right. Thank you.
Okay, Mr. Thompson.
Thank you, Your Honor.
We're on the record now in versus Quack. This is file number 265524. The record should reflect Mr. Quack's present for the court here today. This is the date and time set for sentencing in this matter. Mr. Quack, you had an adequate opportunity to go through the pre-sentence report. Mr. Thompson, about that.
Yes, sir.
Mr. Thompson, are there any additions to the
There are, Your Honor. We have some updates for the court. Court refers to page 1 with the evaluation and plan. Mr. Quack advises that he is sentenced on April 29th.
Okay.
Sentenced to 22 days served.
So 29th, and then 22 days with 22 days served
Yes.
instead of 19.
Yeah, so it's not so much that that it's wrong, it's just an update of what actually happened.
Any objection to those changes?
No objection.
Any other corrections?
The PSI indicates that Mr. Quack is a dropout, high school dropout in that last paragraph of the evaluation plan. He would like to add that he subsequently received his diploma and his GED.
Ms. Koch, any objection to that change?
No.
Okay, we'll update that.
There's some factual things we'll address in allocution, but then if the court goes to his prior record, entry 4, going on to the next page, the Van Buren Township Police Department charge. It's indicated as an active warrant. Mr. Quack believes that was taken care of recently. So he has to strike active warrant or to add resolve to it.
I don't have any verification on that, Judge.
I don't either. But I think that they contacted the jail, and he was taken to Wayne County. I'm not sure, but I do have information that he was dealing with it.
Okay, so I don't mind changing in the narrative that there's no longer an active warrant, but without some kind of confirmation of what.
My lawyer, when I was in Detroit, was reaching out to him to get us a court date.
Okay, so that's still have to take care of that.
Yes, the judge told me I had 90 days to take care of it once I got out, because they had reached out, did anything while I was there for the 3 weeks. So she let me out and said, just take care of it within the 90 days. And my lawyer was already reaching out to him to get us a court date on the matter, just waiting to hear back on it.
All right, so I'm gonna have that remain showing as pending, but the court will ask that the narrative be amended to reflect that there's no longer an active warrant. Any other changes?
Those are the changes. Thank you, Your Honor.
Okay. Ms. Koch, do people have any additions, deletions, or corrections?
No.
Any thing for allocution on behalf of?
You already know Mr. Quack has some issues. At one point when we had a hearing, he was rocking back and forth in a blanket in the jail. This really could have been easily avoided. And he has very little criminal history with a juvenile record, no juvenile record, and one misdemeanor. I think the recommendation is appropriate. I hope that he is seeking the treatment he needs for if he does have some mental health issues. Thank you.
Mr. Thompson.
Thank you, Your Honor. There is a whole picture here where Mr. Quack is a person who's experienced some homelessness. He does have some mental health issues. He is currently trying to address those. He's trying to address those old court cases as we're going through. You know, court's familiar with the facts here. The court recalls the plea colloquy. Mr. Quack was confronted by officers while he was walking on the side of the highway. He wasn't really doing anything other than, you know, technically you're not allowed to walk on the side of the highway. He was surprised. He probably, you know, did not immediately comply with the officers the way he should have. We take issue with saying he was acting dangerously. We think this is a failure to comply with the lawful command, and we understand that's a violation of law, but I don't think Mr. Quack was making a scene or putting officers in danger or those types of aggravated things. I understand the request for straight jail instead of probation. I spoke to Mr. Quack. He said he would prefer probation. He advises he's been in touch with his probation officer in Wayne County. Mr. McDonald says different, that the probation officer in Wayne is waiting to hear from him. I tried to call that officer immediately before the hearing, and she didn't answer, so I couldn't necessarily hear it from the horse's mouth, so to speak. So he is requesting probation instead of this straight jail that Mr. McDonald has recommended. Thank you.
Mr. Quack, anything that you wanted to say today?
Yeah, Honor, I'm the first person to say I've done something wrong anytime, and I never seen those gentlemen on the highway or out stopped and talked to him. I was just trying to get home in the state of mind, and all I was trying to do was find a doctor. I've been pulling blood out of my ear for days, and I had an infection in my ear. So all I was trying to do is see a doctor. I've been to the hospital here 3 times and got sent home 3 times. You know, I was trying to walk the whole way to see a different doctor just to find out about it when all this happened. Maybe I wasn't in my right state of mind or whatnot, but I don't think I did anything dangerous to put their lives in danger or mine. I'm just trying to get through the mistakes that I've made and man up and do what I'm supposed to do. That's all I'm trying to do. I made mistakes in my past, and now I'm just trying to get through it and do it the best way I know. I don't want any trouble from anybody. I'm just trying to restart my life again. 51, and I'm embarrassed of the things I've done. And I just trying to get better and live better each day. That's all.
All right, well, I reviewed the report, so I'm familiar with what the police report indicates happened. I'm also familiar with your background and your circumstances based on information in that report. And I take all of that into account along with what the lawyers had to say and what you had to say here as well. You know, I do remember the plea hearing, of course, Mr. Thompson referenced. You know, the police report just reads different than what you're saying.
I understand.
They indicate that they encountered you earlier and warned you not to walk along the highway. And then they saw you again, and at that point, they initiated contact. Based on the way it's described in the police report, it's hard for me to believe that you wouldn't have noticed them. And maybe that's explained by your state of mind. But I think anybody in a reasonable position would have known that they were police officers and they were clearly making efforts.
So they were hitting on me. I couldn't see them. I didn't even see the cars, so I don't.
Again, either you were in a state of mind where you weren't paying attention, or I just don't believe that you didn't see one of those two, based on the description. And I guess that's really not either here nor there, other than, you know, I've got 2 very different descriptions of what happened, and their description to me is more credible than your description. Don't have a significant criminal history, but clearly, you know, even though this didn't result in any kind of a dangerous situation, it certainly could have. Number 1, walking along I-75, there's a reason why that's illegal, because it's dangerous in and of itself. And then when police are trying to stop you and you're ignoring them, not responding to their demands, it creates a heightened situation that becomes more dangerous for them and for you. And I think that warrants a degree of punishment. This is a 1-year misdemeanor. The court could sentence you to up to 1 year in jail. I don't think that's certainly appropriate given all the circumstances here. I do believe a jail sentence is appropriate, again, as a means of punishment based on the danger that you put yourself in, other motorists, and police that day. So the court is, and I think the recommendation is a reasonable recommendation. I think it addresses that need for punishment and for deterrence, so other individuals understand you're not going to respond, we're not going to comply with lawful commands from police officers. That's going to carry a consequence with it. The court is going to sentence you to 45 days in the Crawford County Jail. You have credit for 2 days served. Court will order a crime victim's assessment of $130. Court costs $325. Attorney fees of $350. The DNA testing fee is $60. $50 state cost. Because this is a misdemeanor, there are no written appellate rights, but you can seek an appeal of the sentence. If you wanted to do that, you would need to file that appeal within the next 21 days. If you have further questions about that, Mr. Thompson can help you with that. Other than that, at this time, you are remanded to the custody of the county. Mr. Garrett, if you could come forward to the podium, please. We'll go on the record. Sorry, Mr. Nickel.
Yes.
Nickel, file number 245299. Record to reflect Mr. Nickel's presence here in the courtroom today. Mr. Nickel, you're for the court for arraignment on some alleged probation violations. Do you understand why you're before the court?
Yes, sir.
Okay. And Mr. Trush, have you had an opportunity to speak with Mr. Nickel today?
I did, Your Honor. I had an opportunity to go through these allegations with him as well as talk to Mr. McDonald. It sounds like there's also another, and I don't know if it's pending or filed, but there's another allegation out there as well. I think we have an agreement for the court today where he's going to admit to the 3 allegations contained in the violation report dated 5/6/26. The other violation would be dismissed. So we would seek to take advantage of that today. By way of the arraignment, though, he'd waive a formal reading of it. I've discussed it with him. We would admit those allegations, and then he is approved for counsel for the potential sentencing hearing, which we'd ask the court, considering that these are technical violations, to set that also for the May 18th.
But pleading to all 3 counts, is that correct?
Correct.
So he has a current hearing on 6/1, not May 18th.
Okay.
Well, and I don't know if that hearing is for the other alleged violation or if it was scheduled for the arraignment, but I mean, this would be a new hearing for the sentencing.
I do believe that the 6-1 was from the prior one that was going to be dismissed, but I'm not 100% sure.
This started, he had a show cause back in February 3rd, or he had a show cause on March 2nd for prior possession or a use of meth. And then subsequent to that, he had additional violations, which is, so I would dismiss that meth use from 2/3/26 and he plead guilty to all 3. I know defenses are usually asking for a quick sentencing date, but you know, when we're doing these sentencings, there's a time that we need to get these reports done because all the violation reports go to Lansing. To have that done on the 18th wouldn't be real feasible, I guess.
How about the June?
Yeah, yes, Judge. That's just the appropriate time frame, approximately 30 days.
All right.
That's fine.
Okay, so Mr. Nickel, is that how you wanted to proceed today with guilty plea?
Yes, sir.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Nickel, you understand that you would have the right to have a hearing as to whether or not you did violate probation?
Yes.
And you understand that by pleading guilty today, you're going to be giving up that right?
Yes.
Has anybody threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anybody promised you anything other than what we said here in court today?
No, Your Honor.
Are you pleading guilty of your own free will?
Yes, Your Honor.
And are you pleading guilty because you did violate your probation as alleged?
Yes, Your Honor.
Back on April 7th of 2026, were you on probation here in Crawford County?
Yes, Your Honor.
Were you aware that one of the conditions of your probation was that you were to not use any controlled substances?
Yes, Your Honor.
And on or about that date, did you use methamphetamine?
Yes, Your Honor.
Same thing for May 6th of 2026. Were you still on probation at that time?
Yes, Your Honor.
And did you use methamphetamine at that time?
Yes, Your Honor.
Also, were you aware that one of the conditions of your probation was that you were to participate in any kind of substance abuse treatment that might be required by your agent?
Well, now, at first, when I first got put on probation, I was clean for like the first year and a half or so. I was on probation. I was doing good, walking the straight line. I did my my assessment through what the court had recommended. I do Catholic Human Services, and it got recommended that I did not need treatment at the time. And then I did violate again, but it wasn't like I thought that my stipulation for having to take the drug counseling was not not a for sure, like I have to do it anymore thing. But honestly, at the end of the day, that's what I need. Like I need that. So like regardless whether it was I didn't know if it was for sure still a stipulation after it got recommended that I didn't need it the first time, but like I said, I need it regardless of whether it was a stipulation or not.
He was instructed by a supervising agent to get back into treatment after his violations that got him back into the court. I think we even talked about it.
Yeah, we did.
At the hearing that he needs to, get in there, the goal was to get him in, he was gonna get himself in inpatient treatment and avoid kind of where we're at now. So he was instructed, what he's saying is probably true. He probably did initially do what he needed to do, but he was instructed subsequent to that. That condition didn't go away. It's just, it's still there.
Is that a fair statement?
Yeah, I understand that.
Okay. All right, the court finds that the plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that Mr. Nickel did violate his probation as alleged at all 3 counts. The court will accept the guilty plea. We'll set this matter for sentencing on the June date. You said everybody.
Yes, June 15th.
So that'll be your next date in court, Mr. Nickel. Without anything further that we need to address in this case.
No, thank you, Your Honor.
Understood there.
I don't know if there's a bond set on the warrant, but I think ultimately we need to set a bond. From talking to Mr. Nickel, I don't think he intends to post it, but I think we need to put something in place.
Well, I mean, he's pled to the probation violation, so that is entitled and sentencing.
I guess I don't know. I mean,
Typically, we do set a bond, Judge, but it's up to the court. If we do, I would just ask for like a $10,000 range bond with the instructions. I'll talk to Mr. Nickel that if he does post that he needs to get a hold of me when he gets out.
Okay. All right, since there's no objection, then the court will to that bond. Did you want to address the amount suggested by Mr.
again, I think it's academic from talking to Mr. Nickel again. I don't think he intends to post it because I functionally think that he wants to create in the future. So again, I think he's best served to serve potential time up front.
Okay. So I will set bond in the amount of $10,000 cash or surety with all standard conditions of bond and all terms of probation. Thank you, Mr. Nicolette. That concludes our